All right, sir, are you Michael Price?
Yes, Your Honor.
All right, we'll go on the record in People versus Price. This is file number 216219. The record should reflect Mr. Price is present today by video from Otsego County Jail. If I could have counsel put your appearances on.
Your Honor, Richard Trush on behalf of Mr. Price.
This is set as a final status conference today, and Mr. Trush, how did we want to proceed in this?
Your Honor, we intend to proceed forward to the trial.
Okay. Are there any issues, Mr. Trush, from your side that we need to address prior to the trial date, which is January 30th?
There are, Your Honor.
Okay.
There's three issues that I think are out there to be addressed in regards to the file. So the first of which, and on Friday, the prosecutor filed witness and exhibit list as well as proposed jury instructions. The prosecutor's witness list identifies lab tech or lab analyst. It doesn't identify a person on the list. And this is problematic for two reasons. I would indicate the witness and exhibit list just identifies that. I do think, in fairness to the prosecutor, in the jury instructions, they do identify someone that I recognize as a lab analyst. I don't know if they are the lab analyst or not, because I still haven't received the lab report in this file. So I identified that issue, and I want to break the layers of that apart in a moment. Additionally, they identify the CI only by the CI number, which again, I think is problematic because I'm entitled to Brady information on the CI's potential criminal history. With just a CI number, that leads me to believe two things. One, that the prosecutor doesn't know the name of the CI right now, and maybe I'm wrong on that, but certainly it doesn't give me the ability to find any information out about the CI and potential Brady information regarding that CI. So to break those issues apart a little bit, in regards to the lab analyst, again, I'm surmising a few different things. Lab analyst is listed, which leads me to believe that the lab might not be complete. Because there is someone listed in the report, I think possibly it could be. I think it's problematic though, because Court Rule 6.201 requires that anyone who's going to offer expert testimony be identified 28 days prior to trial. It also identifies that I'm entitled to their CV as well as anything they're relying on to form their opinion. Most importantly, the lab report. I don't have any of that yet. Additionally, I think we have another layer of problem there because so with that in mind, I object to any expert testimony being offered. Additionally, I don't have a lab report, so I would object to any lab reports being tendered at the trial because again, I haven't been provided it. We're now 10 days prior to trial. I think that bears additional background here. This is a case that has been pending basically since I think it's a 2021 case. I reached out to Mr. Gilo. Mr. Gilo indicated to me his appearance was filed on September 27th of 2021. He also, his office indicated to me he has never been provided with a lab report at any point in time. My appearance was filed on October 28th of 2025. In response to that, I did not get any lab report of any kind tendered to me. I also think it's worth noting, prior to the 28-day period, I contacted the prosecutor's office about two specific issues. The first issue was I contacted them about Mr. Price's criminal history in order to accurately score out the offer that they had made to me. I additionally advised the prosecutor at that time I still was not in possession of a laboratory report. And again, the timing of this is important to me because I expressly made sure I reached out before the 28-day period would have lapsed. Right? I reached out, I think, 31 or 32 days prior to the scheduled trial date. So again, I object to the lab being admitted at a trial, if one even exists. And then lastly, again, obviously the Brady issue with less than 10 days to trial, if there is Brady information, I certainly would be hard pressed at this junction to be able to go and get certified copies of records. I mean, even if it's 14 days before trial, I think I could probably make arrangements to get them. But knowing my schedule, I'm in trial the next 3 days. I don't see how I could get the Brady information if I need to get certified copies prior to the trial date. So those issues are all out there.
Okay, Mr. Rowland.
Couple of different matters. First off, in regards to the Brady information, I think that's already been provided to defense counsel. I do know the CV of the person we believe to be the lab report was provided to defense counsel on numerous cases already, so they already. As to the current lab situation, the reason the defense counsel does not have it is because our office doesn't have it. And as defense counsel is well aware, because of actions by the defendant himself, there were delays in this particular matter. This case goes all the way back to 2021, and the defendant decided to abscond himself from the court. Now, that being said, once it was determined that this matter was going to be scheduled for trial, our office directed, I know because I did it personally, the officers involved to have the matters immediately taken to the crime lab for analysis. As Mr. Trush is well aware, even though the lab may in fact already be done, they do another internal at the lab before the lab report is released. So although we have an indication of what the lab's going to say and who it's going to be, I don't have the hard copy yet to provide it to the lab. But that would have been provided well in advance. As Mr. Trush noted, there is a person listed both under the witness list and under the instructions in this particular matter as to who that lab person is. As to the CI, that's a little bit of a different situation because, of course, I'm looking now to find out when that was sent to the defense. I have asked as well, by the way, for the CI's full name and CCH's, so that information can be provided to defense counsel. And that information went out on the 16th of January.
All right, so there is no lab report as of right now. Is that what you're saying?
There is no, well, there is no physical lab report in the hands of the prosecution that I can make a copy of. I have requested, and apparently according to my office manager, who's now back, we can go into the system, and although the lab hasn't been forwarded, the copy of the report hasn't been forwarded to our office yet from the crime lab, we can print out a copy of the lab report. It'll be the one that doesn't have the second verification signature, that it's been reviewed by the lab director, I guess. That's that review process that I was referring to. Why we don't consider, I don't know, but that's just the circumstances apparently at the crime lab.
And who are you calling as the witness?
I believe that, let's see, I had it listed on my witness list.
I think it's Mallory.
I think it's, yeah, Mallory Smith, I think it's who it is.
I believe that's her name.
That's the lab tech.
Yeah, she's the forensic scientist for which Mr. Trush's office received her CV on 3 other cases in the last year. So he has a copy of it. It sounds like it has.
Admittedly, my argument here isn't really necessarily that I haven't received a CV for that particular lab person. I think it is likely very accurate that I have received it in regards to other files. Mm-hmm. The more fundamental problem is I don't know her opinion. I don't know what she's saying this substance is. That's kind of a fundamental issue to the case.
All right, and then Mr. Rolla, I'm still not sure. Did you identify the name of the CI?
No, that's what I asked information for. I'm waiting for that information coming back. I cannot tell this court, and looking at the file that, and I want to see if we got it again today. I have the officers coming in today, and I will be asking them about that very matter. I did make the request for that information as soon as I had the fact that they.
Okay, so, and Mr. Trush, I just wanted it to be clear for the record, what are you asking the court to do with, I think, like you said, maybe, I'm not sure, but I think there's 3 issues here. There's the admissibility of testimony of the lab tech. There's the admissibility of any lab report that is produced between now and the date of trial. And I guess, admissibility of testimony from the CI?
So in regards to the Brady information, and I'll kind of start there and work back, because frankly, I mean, I think the Brady issue is probably the cleanest. I mean, I think Brady imposes an obligation that they provide it prior to trial. I don't think there's a specific timeline that Brady outlines that says, hey, they have to provide it 14 days or 10 days or anything specific. So I guess at this junction, what I would be asking the court to do is just order that it be provided. You know, my hope would be that once we identify the person, identify the history, it won't present a problem. And I suspect even absent a certified copy, I suspect that the officers are likely aware of the history and are probably going to be the ones who ultimately run the lien that produces that info for me. So I guess that's what I would ask in regards to that.
Actually, Judge, and now looking at the file, I can now indicate we have the name of the CI.
Okay, great. Okay.
And Mr. Truce will be well aware and familiar with this individual because I believe he's representative on a number of occasions. The CI in this particular case, what are the information?
Well, I don't think we should put that on the record.
I don't either. All I need to know is.
We have it, Judge.
Okay.
We have it now.
So then what are you asking with regard to the lab tech and the lab report?
I mean, in regards to the lab report, I mean, I'm asking that it be ruled inadmissible. In regards to the lab tech, I'm asking that they not be allowed to testify as an expert. Again, because I don't have the information with which they're basing their opinion.
So I get why. I just want to make clear what decisions I need to make.
And I guess in the alternative,
the judge explained the charge clearly. Leaving the scene wasn't just a mistake, it was a serious crime. She understood the consequences, raised her hand, and pled guilty. In court, silence is heavy, and the truth always comes out.
I will say to the court, I puzzled over how to do this a great deal. I consulted with my partner, consulted with my client about the best way to address this issue. Because frankly, to the court, there's somewhat of an incentive for me to sit on this and wait till a jury is seated and raise it once jeopardy is attached. I think that's incredibly wasteful of the prosecutor's time, my time, the court's time, the juror's time, and taxpayer money. In the alternative, I would ask the court to conduct an evidentiary hearing as to why the lab is not completed. I mean, we're 4 years into a case. I understand Mr. Price bears some responsibility for it being that long into it. But I think there's a real question of, one, the wisdom of waiting until a jury trial is demanded before you have the laboratory report performed, which is what it sounds like has happened. But secondly, I guess I would indicate, if that's the position the prosecutor is going to take, this court generally has a practice of asking what the time frame that would be required to be prepared for a trial would be. And I think that needs to be taken into account if that's the position they're going to take. We all know that absent putting a rush on a lab, identifying a substance like this typically takes 3, 4, 6 months. I mean, so there's a legitimate question here to me. If the court isn't going to rule them inadmissible, I think the court should conduct an evidentiary hearing as to how do we get to this place.
What would be the outcome of that hearing? In terms of an order by the court?
Well, what I would be asking the court to do is assess whether or not, again, effectively there's good cause to allow it to come in. So that is to say, I think the scenario is different. And again, I don't know what I don't know. But let's assume for a moment that this laboratory report was actually completed 3 years ago. I think that's a very different scenario than if the laboratory report is actually completed 3 days ago. I also think, again, what triggered the laboratory report to be completed. So, I mean, again, if the situation is the prosecutor waited until after a trial is demanded to request the laboratory report be completed, I think that is a factor that the court should consider as well. I mean, I think everyone can agree we don't want to be in the scenario where 10 days before trial, we're here, right? This is exactly where everyone doesn't want to be.
Well, so I guess number one, I'm not going to conduct an evidentiary hearing. I don't think the reason why it's not prepared at this point isn't really relevant. The prosecutor makes their decision. I don't, about when to ask for things to be processed and the timing of the preparation of their case. I don't think that's something that's within the scope of the court. And things are either produced timely or they're not. And if they're not produced timely, there's an analysis that goes, through with that. Is there prejudice and so forth. And I think that's what the court's going to have to make its decision on. Whether or not there's a lab report or not, that's an evidentiary piece. It's not dispositive of the case. The prosecutor, I would assume, could still make an argument to a jury even without a lab report that it was methamphetamine. And so I think even if the court were to say that the report's not admissible, I don't think that necessarily results, even if we have a jury charged in a directed verdict or something like that, because the prosecutor can make other arguments based on other pieces of evidence that substance was methamphetamine. Certainly not as strong as a lab report, but not outside the realm of possibility. So again, I think that's another reason why I don't need to conduct an evidentiary hearing, and why while I appreciate certainly Mr. Trish your thoughts on not wasting resources and so forth. Again, I think it all comes down to the prosecutor, how they prepare their case. And again, it's either timely or it's not. And if it's not admissible for untimeliness, then that's a burden that they bear. And then that's a decision that they have to make as to whether they want to go forward without that evidence or not. So all that being said, I am going to order disclosure of the confidential informant and any information related to that was in the discovery request from the defense, and that disclosure be made forthwith. And so Mr. Church, if you can prepare an order that states that. In terms of the admissibility of the lab report and the expert testimony, I'm going to review that. I will issue a written order on that within the next 2 or 3 days. And that's how we'll address that. We will plan on going forward with the trial as scheduled. Outside of that, Mr. Trush, are there any other issues we need to address for today?
I don't believe so. I submitted jury instructions. I think the prosecutor has submitted their jury instructions. I think we are prepared.
Have you been able to communicate with Mr. Price to ensure that he's got appropriate clothing and so forth for the trial?
We have not discussed that matter specifically, but I will make sure that he has clothing.
Okay. Mr. Rolla, anything further from your side today?
Yes, Judge, I would indicate to the court, just so as a surprise, if our office is told we cannot get the lab report prior to the date of the trial, I would anticipate a dismissal well in advance of trial, as much as I can do it once I have that verification, because we would be proceeding without that information.
Okay.
And as far as the grading material in regards to the CI, I'll be able to very now easily provide Mr. Truce with a copy of the CI's up-to-date background, since we have a PSI from him from not too long ago, now that I know who that individual is.
Okay. Mr. Price, do you have any questions about how we're going to proceed with your case?
No, Your Honor.
Thank you. That's all for today. The court's going to disconnect from jail at this time. Come right up to the podium then. Thank you. The record should reflect Ms. Cornett's present here in the courtroom today. Mr. Trush, can you tell me the status of this file?
Yes, Your Honor. I've had discussions with the prosecutor, and I've also had discussions with Cornett. The prosecutor is not offering a reduction here. After going through the various different options and potential outcomes with Ms. Cornett, we would be making an admission as charged.
All right. Ms. Cornett, can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Ms. Cornett, are you currently on any kind of probation or parole? And you understand that by pleading guilty to failure to stop at the scene of an accident resulting in serious impairment or death, that is a felony that carries with it a maximum possible penalty of up to 5 years and or a $5,000 fine. With that in mind, what is your plea to that charge today? Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. You understand all those rights. And you understand that you're going to be giving up and waiving all of those rights by pleading guilty. Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it, you would have to ask for the Court of Appeals to hear your case. If they said no, then you wouldn't be able to go any further with that appeal. You understand that? Has anybody threatened you with anything to get you to plead guilty? Has anyone promised you anything other than what we said here in court today? Is it your own free choice to enter this plea? Are you pleading guilty because you are guilty?
It was just one moment after the crash. She stopped, but she didn't stay. No police, no checking the victim. Later, inside the courtroom, she admitted it out loud. That single choice turned into a felony, and the court didn't ignore it.
This happened back on October 20th of 2025. Is that the correct date? On that date, were you operating a vehicle on North Ohio Avenue here in Gaylord? And did you fail to immediately stop and stay at the scene of that accident?
I did stop. I didn't stay.
Okay. And Mr. Trush, is there any factual dispute about whether there was a serious impairment or a death here?
So, Your Honor, we would indicate, we have medical records from Otsego Memorial Hospital that indicate that there was an injury to the
16-year-old's fracture.
a fracture to the tip of the fibula. And at least from the records, it would appear that he was in a walking group for some time. It's
Okay.
not clear how much time.
All right. Again, are you disputing whether there was that would qualify as a serious impairment under the statute?
We would not.
Okay.
We would agree.
All right. Mr. Roll, are you satisfied with the factual basis?
Just so there's no confusion.
I think that's the testimony.
And again, I just want the record to be clear that way, so if we have to deal with it at a later time, I don't have to.
All right. Counsel, are either of you aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Or aware of none.
Are you both satisfied that the court has complied with statute and court rule in taking up this plea?
People are satisfied, the court's compliant. Thank you.
Defense is satisfied.
Ms. Cornett, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there is a factual basis to support a finding that you are guilty of this charge. The court will accept your plea today. You're going to meet with Mr. DeLeo before you leave. He's from the probation department. They're going to set up a time for a pre-sentence interview, and we'll schedule this for a sentencing hearing. You'll be notified of the date and time of that hearing. It's important between now and then that you stay in touch with Mr. Trush. Do you have any questions? Okay, thank you. That's all for today.
Your Honor, if I may, I would suggest to the court setting a little additional time for this sentencing may be appropriate. From my discussions with the prosecutor, I think it's likely that there's going to be at least one, maybe two victims who would wish to allocute. And I would indicate, I think there are some things that are factually in dispute. Again, I don't think it changes the plea, but I do think there are some things that will be in dispute.
Okay, thank you. I appreciate that. Heads up on that.